Yes, Judge.
And is that consistent with your discussions with Mr. Davis, or is he expecting to have a hearing?
No, that's fine, Judge.
Okay, so this is on a real property, and can you just give me a short synopsis of the nature of the controversy?
Yes, it's a dispute. There was a kind of a lease to own situation, one of those, and there's disagreements as to payments.
Okay, let me give you the name of the mediator that I want you to go to. And or do you need more discovery, or is a setting in 3 months too far away?
That's perfect, Judge.
Okay. Okay, I'll be right back. I had to turn myself off this time. Okay, I'm going to refer you to mediator Carlos Cardenas.
Yes, Judge.
And last I heard, he's taking clients actively and all. I've never had him call back and say he couldn't. Obviously, if you can't get a mediation with him, you can call my court coordinator and we'll get you on another referral. Okay?
Yes, Judge. Thank you.
Thank you, sir. You're excused.
I have another case. I'll wait.
Oh, you have another
I'll
case?
wait.
I'll take that up right now. But
Okay.
your next setting is going to be in 3 months for status.
Yes, Judge.
And then you should have mediated by then. Maybe you won't even have to have the setting. Okay, what other case are you here on, sir?
Yes, Judge. 2024 DCV 2010.
2010. All right. Tony Landavasto, etc. Sean Javier, defendant. Mr. Quiñones here present. Oh, okay. So this is pro se is what I have listed on the docket sheet is Sean Javier Quiñones. That's not relation to you, is it?
No, there's no relation, but that's my client. Mr. Quiñones is my client. No relation. And
who's pro? Pro se is Tony Landavaso. Okay, AKA Antonio Landavaso Jr. Is he here present? Do you know anything about his Mr. Quiñones? Anything about his presence, or have you been in contact with him?
no, we've tried to reach out, Judge. He's not responsive. I filed this motion to compel him to appear at depositions. He's refused, and so I need to move this case forward. So I'll be filing motions after today. If he's, I haven't heard from him. I don't know what's happening.
All right, let me get the court reporter on here.
Yes, Judge.
Rachel, say when, please.
I'm ready, Judge. Thank you.
Okay, thank you. Calls number 2024 DCV 2010. Tony Landavaso Jr., a.k.a. Antonio Landavaso Jr. versus Sean Javier Quiñones for a setting on a motion to compel a hearing. May I have announcements of counsel, please?
Yes, Your Honor. Carlos Quiñones on behalf of Sean Javier Quiñones. I'm ready, Judge.
Okay. And then plaintiff, who's listed on the docket sheet as pro se, Tony Landavaso Jr., aka Antonio Landavaso Jr. Are you here present? Okay, I don't see anybody here, and I already had a conversation about not having a presence by this party. This is a Zoom hearing, but it's a hearing nevertheless. And if Mr. Landavaso's listed as pro se, that means he's probably made an appearance that got him that status. He's required to follow all the rules. I don't know that we've had a hearing where I've told him otherwise. Have we had a hearing before, Mr. Quinones?
Not with me, Judge. I jumped into the case a little late.
Okay. So, but I'm not going to do anything special to secure his presence, even though he's pro se, because if he filed an answer and then he's been non-responsive to enough things that a motion to compel hearing has been filed, I'm going to, outside his presence, take up the motion here in open court so that I can have an idea of the nature of the relief sought. Robert, my court coordinator, is there any indication of any calls from you or any of the staff regarding why the plaintiff isn't here today, or did he call in and say he couldn't be here?
There has been no communication with the court, Judge.
Okay, can you please check the docket on our end to see if a motion for continuance was filed?
No motion for continuance filed, Judge.
Okay, and then lastly, Mr. Quinones, do you have any notice of the lack of the presence or even an off-record attempt by the parties to resolve the absence or to delay this hearing?
Yes, yes, Your Honor. I haven't had any communication with him. We've been calling him. He's listed a phone number on the petition. We've called that number to no response. I've also emailed him and have not received a response. The email is also on the petition, Your Honor.
Okay, thank you. So give me the I've called the case and I'm hearing the nature of your motion. Can you just give it to me so that you can also explain to me the type of order that you'd be sending me?
Yes, Your Honor. Thank you. The motion I'm requesting is to compel a deposition. I'm requesting an order from the court, which that order I will serve upon him, ordering him to appear at my office for a deposition. The date that I have available is May 21st, 2026 at 9 a.m. And I'll prepare an order and send that over to the court.
He's got notice, however unverified it is in the sense of not hearing from him. But you've already given him the May 21, 9 a.m. setting?
I have not given that to him. I've given him other settings. I've given him 3 as of this point before filing the motion. And so that's why we're here, Judge. He's missed 2 prior depositions scheduled. March 27th of last year and again May 21st of last year, and he has not been present in any of those depositions.
Okay, have you asked for attorney's fees in your motion to compel?
No, not at this time, Judge.
All right.
I'll wait for another motion.
So I'm going to ask you to send him the notice the way I would order it for a lawyer to get notice on behalf of a client. And so, whatever the email, certified, unreturned, or whatever it is that you have for the date that you want. So, and then I am ordering him to compel his appearance on that date at your office at that time. So, if you give me that order, and I guess besides filing the order, but I file it after I sign it. By you sending him the order and the notice of appearance, that I think should be enough for me to act if he's in default after that.
Yes, sir.
Do you have any other requests or any other ideas?
Not at this time, Judge. That's perfect. Thank you.
And that sounds satisfactory to you right now?
Oh, yes. Thank you.
Okay. All right, so I'm granting the motion to compel. Please send an order for me to sign. If it's not signed by the end of next week, don't be shy about calling to find out what the delay is.
Yes, thank you.
But it should get signed and filed. All right.
Okay, thank you, Judge.
And then, so you have the deposition, and then we still need a setting so you don't fall through the cracks without one pending. Did you already have a jury setting or a status hearing before you filed this motion setting?
No, Judge, we can set, you can order to send your staff to send me that. That's fine too.
All right. So Robert, what kind of settings do we give when this happens on our own, or should we have Mr. Quinones designate the kind of setting that he wants?
Judge, I can send him the available dates and he can pick one and then I'll set it.
Like for a status, right? After the May date?
That's correct, Judge, and I think I've already sent him the available dates, both on the jury and status hearings.
Okay, and so for the status hearing, Mr. Quinones, if you don't have an appearance by May 21, I'll take up any motions you file at that status hearing, okay?
Okay, perfect.
All right, thank you. You're
Thank you.
excused.
Thank you.
All right. Okay, I have Baldomero Olagues Melero versus Geronimo Trail Town Homes, etc. Who's here for that, please?
Good morning, Your Honor. Oscar Lara here on behalf of Mr. Baldomero Olagues Melero.
Okay, good morning.
Good morning, Your Honor. Joe Spencer on behalf of El Paso Roofing and standing in for Jake Spencer on behalf of Isaac Torres individually.
Okay.
Good morning, Judge. This is Cindy Vasquez
Give me 1 second, please. I'm sorry. Joe Spencer is not a name that I would forget, but I need to put it in the right column, Mr. Spencer. Okay. Who next? I'm sorry. Who else is going to make an appearance?
Yes, Judge. This is Cindy Vasquez. I am appearing for defendant Hunt LIHTC Geronimo. I would like to let the court know that Miss Marisa Ibarra Williams filed a motion for substitution withdrawal of counsel and will be taking over this case on behalf of defendant Hunt LIHTC Geronimo.
And Your Honor, we just received a copy of the signed order that we have provided the court. Mr. Oscar Lara is not opposed to my substitution, so I believe your court coordinator or someone from the court staff sent that to us right before the hearing started. So I will be taking over, as Ms. Vasquez said, for Hunt LIHTC.
Okay, call reporter so I can get that substitution in, and then we can get on with the rest. Rachel, say when, please.
When?
Okay, thank you. Calls number 2022 DCV 3824, Baldomero Olagues Melero versus Geronimo Trail Townhomes Ltd, CLJR Geronimo LLC, IBI Geronimo Trail Townhomes LLC, Davis Street Corporation, Hunt LIHTC Geronimo Ltd, Isaac M. Torres individually, and El Paso Roofing LLC. May I have announcements of counsel for the record, please?
Yes, good morning, Your Honor. Oscar Lara on behalf of plaintiff Baldomero Olagues Melero.
Good morning, Your Honor. Joe Spencer on behalf of El Paso Roofing LLC and standing in for Jake Spencer on behalf of Isaac Torres individually.
Ms. Vasquez, announce, please.
Yes, Judge. Cindy Vasquez. I'm sorry, I think my internet's slow. Cindy Vasquez on behalf of defendant Hunt LIHTC Geronimo.
Marisa Ibarra Williams is here because she's going to, if I sign the order or give permission, she's going to take over on a motion to substitute counsel or to withdraws counsel. So, Ms. Ibarra, you're on here, right?
Yes, Your Honor. Yes,
Okay.
and yes, I'll be substituting them for Ms. Vasquez.
Okay. So now let me take that substitution up on this extensively represented litigation. Ms. Vasquez, you were saying that you are going to withdraw as counsel because Ms. Ibarra Williams is going to substitute in. So please describe that for the record, and then I will appoint Ms. Ibarra Williams.
Yes, Judge. Defendant Hunt filed a motion for withdrawal and substitution of counsel. Ms. Maritza Ibarra Williams will be taking over for the defense. The client is in agreement and understands that the motion has been filed and that Ms. Maritza Ibarra Williams will be taking over the case if the order is granted by the court. And that's why we're here. Plaintiff's counsel is unopposed to the substitution and my withdrawal.
Okay, and Ms. Vasquez, I didn't quite get, you were the attorney for Hunt, and now you're withdrawing?
Yes, Judge.
Okay, and of course your client's okay with that.
Yes, Judge.
All right. So it looks like you all took care of all the preliminaries and all the notifications, and I'll go ahead and grant that. And then
Thank you, Judge.
whoever's going to submit the order, whether it's Ms. Ibarra Williams as appearing or Ms. Vasquez is withdrawing, sign that. Actually, I just got it. I got an order ordering granting defendant Hunt LIHTC motion for withdrawal and substitution of counsel. And then there's agreements by the listed parties, and I will go ahead and sign that now.
Thank you,
Your
Judge.
Honor.
If there's nothing else for me to sign to complete this transaction, let me get on with the next part of this. And you can be excused, Ms. Vasquez, or you can continue to stay here as you wish or as you're required to by your ethics.
Thank you, Judge.
All right, so it's signed. It'll get filed. So now, it was a motion hearing. Was that the only motion?
No, Your Honor. So a little bit of backstory, Your Honor. This involves a January 20th, 2021 incident where my client was working on top of a roof and he fell down and he was seriously injured. We brought suit amongst all the various defendants that we believe were involved. We've been trying to move this case and push this case forward. We've been trying to coordinate deposition dates and nobody wants to do so. And every time we've tried to notice the depositions, they get quashed, and that's why we're here.
Okay, Mr. Lara, did you
Yes.
file a motion, or you just giving me this background information as something that business that needs to be taken care of among the parties?
The defendants filed their motions to quash, and I set them for hearing, Your Honor, because I
Okay.
need deposition dates.
No, I got it. Okay, so who filed a motion? Who filed a motion to quash? And what's that all about?
I think most of the defendants did. I know that I did on behalf of El Paso Roofing. It's really simple, Your Honor. The plaintiffs have unilaterally set depositions. They do not reach out and ask for dates. We have asked them over and over for dates, and all we do is we didn't get never response, and all we did was get a unilateral deposition date. So
That is not true. That is absolutely false. I have
Hold on a
emails
second.
showing
Hold on.
so.
Lara,
Stop.
let me finish.
Excuse me, Mr. Lara. You wait till I recognize you, please, okay?
All right.
All right, continue, Mr. Spencer.
Thank you, Your Honor. All we request from the plaintiff on numerous occasions is to have communication so we can coordinate dates, and we'd be glad for the depositions.
All right. Mr. Lara, I'll give you a chance to respond, except let me just make this comment because it may make a response unnecessary. All of the parties here are experienced litigators and well respected here and well respected in this court. So a unilateral setting of a deposition when another party is asking to be in agreement with it is a decorum that is often practiced. I also am familiar with the plaintiff's counsel, and you know, when you're trying to pursue on behalf of your client, you got to find who's responsible. It's appropriate to name them in a lawsuit. Maybe in the corridors or whatever, somebody's saying, "Oh, they're filing all these people." Well, I don't know how else a plaintiff can find out who's going to be responsible. So I am not. I don't want to get into who he said or she said. I've already granted a substitution of counsel, and I'm going to ask the parties to. Well, first of all, if the effect of what I'm asking is going to quash your subpoena, your deposition notices, then so be it. It's not done on any kind of merit. It's just being done because of all the parties and the obvious seriousness of the case. When I take into account the quality of counsel that has been hired on these cases. Okay, so I am going to, and now that there's a new lawyer, I'm going to ask that you all follow the normal conventions and notification to set depositions by agreement. And then if you can't agree, then set your motion or file your motion to compel, and I'll hear it in that manner. But right now, frankly, I just think it's going to be too difficult with all the parties and all the lawyers to go through a hearing where I have to do that in the Zoom setting. The other thing is this: I noticed that I guess most of the lawyers are from El Paso.
Correct, Your Honor.
Yes,
Okay.
Judge.
So I don't want any more Zoom hearings on this case. Robert,
Perfect.
you shouldn't have to note that. Who said perfect?
Oh, they said yes, Judge. Perfect.
Mr. Lara? Mr. Lara, I'm not going to
Yes.
put up with that, okay? Listen to me.
Okay.
Look at the camera. Listen to me, okay? Don't say perfect, because now you got an edge over the other parties. I want respect in my court as if you were in front of me together, all right?
Yes, Judge.
That is not proper, in my opinion, but I want to just continue moving on, all right? So I actually accommodate with Zoom parties, but if everybody's from here and it's that kind of case, I want all the settings live, and then I don't want to count on somebody saying, "Oh, you know, somebody else said it by Zoom, and I got this notice. You all heard what happened to me on the other case." And I don't make a record of every single thing that I say and do. I rely on the parties to be professional enough to to set live hearings when I say so. I want all of, so I'm not issuing an order, a written order, but I want all of the hearings on this case set live before the court. And I can accommodate that, and Robert can accommodate that for you. Okay? Anything else?
Nothing further at this time, Your Honor.
Okay,
Nothing
thank you.
further, Your Honor. Would we be able to, I guess the only thing we would request, could we have maybe a deadline to maybe have depositions by, let's say, like July 15th or something?
Mr.
That
Lara,
way,
Mr. Lara,
yes.
you don't get it. I'm not giving relief right now. I'm
Okay.
telling you, set it for a hearing, and I will come, and ask for what you want. You want me to take a side or to, make an order on behalf of the plaintiffs, and I got a whole bunch of quality defense counsel, and I don't like to make a decision like that over Zoom just because you happen to throw it out right now. Okay? You go through the regular convention of dealing with the parties, like your law firm normally does. And I'm not going to go into whether who's at fault because they won't set it. And I don't want to hear, Mr. Spencer gave me enough of a background, but he knows I don't like to hear the nitpicky stuff about your negotiations and stuff. So let me take it up live when you're in there. Then you can do it to their face in front of me, and I can go there, and I do respect the zealousness of the parties. So my answer to you is no. Set it for a hearing if you want me to set a deposition that you can't set yourself. Okay? The other thing that I want to cover right now is I take it there's been no mediation.
No,
Is that
Your
correct?
Honor.
Okay. There wouldn't be normally because everybody wants a little bit of an opportunity for discovery. So the next time we meet, I'm also going to be looking into whether the case is ripe for mediation, and I will order it. Unless you all agree to go to mediation on your own. And we all know if one side doesn't want to do it, then it shouldn't get done. Come to me and I'll break the tie. All right? Thank you very much. And you're excused if you don't have any other matters before the court or on this case. Thank you.
Thank
Thank
you,
you,
Your
Your
Honor.
Honor. Have a good day.
Thank you. All right. Well, they all left, so I guess I don't have any other matters. Let me pick up the next case. I have Wells Fargo versus Miriam Garza.
Yes, good morning, Your Honor. Samantha Razzo appearing on behalf of Plaintiff Wells Fargo Bank.
Okay. Have you been in my court before?
No, Your Honor, I have not.
Well, it's not always like this, Ms. Razzo. Ms. Razzo.
It's a little excitement in the afternoon can do us
Well,
all a little good.
you know what? I don't mind even explaining this because we have other parties, and actually we have this hearing is live, so anybody can be watching it. But Zoom hearings became popular during COVID.
Oh, yeah.
I try to go with strictly live, and a lot of the parties liked the efficiency of Zoom hearings, but I'm not able to control the parties when it's a contentious litigation. That's the first.
Yes.
And then the second thing is, I will, just for the benefit of anybody watching here that's not familiar with the legal market, I think the Zoom hearings have permitted more out-of-town practitioners. And I don't hometown based on the litigation, but I also am aware that a lot of El Paso lawyers are now practicing in other jurisdictions in a vibrant economy that changed after COVID. So,
Oh, yes.
all right. So, Ms. Razzo, yours is a default hearing, and just explain to me. And Wells Fargo is here. First of all, I'm going to ask Robert to check while we're talking, to check and see if anything's been filed, because sometimes something will get filed by a party, a pro se party, and you won't be aware of it. So, Robert, if you can go through that. But assuming that it is a default hearing, can you just tell me what the amount in controversy is, and the amount that they're requesting in damages, and the service?
Yes, Your Honor. So with this, our motion for default judgment is the one that we filed June 30th of 2025. Our petition was filed on December 3rd of 2024, and we have served defendant with citation and petition on December 21st of 2024.
Okay, let me ask
This,
you that. Was that personal service, or was it?
Your Honor, apologies. I hate to delay that. Let me double check again. I had it noted
Okay,
somewhere.
it's important to me, so it's not a waste of my time.
Here. Let me double check that return, Your Honor. There we go. I believe it was personal, but yes, Your Honor, they were personally served.
Okay, I mean, you didn't get substituted service on it. Okay, I'm sorry, continue.
Yes, yes, Your Honor. So they were personally served with citation and petition on December 21st of 2024. And we are not seeing that an answer has been filed by the defendant at this time, or at the time that we had filed. And we did include an affidavit of plaintiff's employee, which includes business records for the account of the debtor in this case, which includes the consumer credit card agreement. We have
Credit card debt.
Yes, Your Honor.
Okay, and how much is it for?
Yes, it's $9,853.07. And then we also
When
included
was
the
the last
declaration.
payment made from your records, please?
The last payment was made, it was in the amount of $290 on November 5th of 2023.
Okay. And then are you asking for attorney's fees?
Yes, Your Honor, we are. We did include a declaration of Thomas Sellers, who's an attorney with our firm. And on there, he is providing the attorney's fees in the amount of $800 through obtaining default judgment, are reasonable and necessary for the legal services that have been provided in this case, as well as in comport with the customary fees.
If I may, we're not on the record, but $800 is fair. I used to do collections when I got out of law school over 35 years ago. And back then, a reasonable fee was even considered a percentage of the amount owed. But 800 appears to be that's why I ask what it is.
Yes.
And most creditors like your client either get it or have just set up a reasonable policy and have been able to work out plea agreements with attorney agreements that accommodate these types of judgments. Some of them are uncollectible, but they're able to get good lawyers on them. So I think I heard everything that I needed to hear except the interest. What do you ask
Uh,
for?
no interest on that, Your Honor. And then we also,
Post judgment.
and I, no, Your Honor, I think we go just straight off of what we have. We go off of the balance, and then the
Well, your
attorney's fees.
default judgment doesn't include post judgment interest?
Let me see. I do not. One second.
Judge, this is Robert. There's no answer filed.
Okay, thank you.
I don't.
Okay.
We usually do the damages, just the balance and attorney's fees.
Okay, all right, that's fine. So submit your default, and if you don't get a signature by the end of next week, don't be shy to call.
Of course.
And then it'll just probably when we file it, it'll get when I sign it, it'll get filed, and you'll get notice of the filing, and that way you'll know whether to close your file or not.
Yes, Your Honor. And then I did just want to make clear for the record as well, included in that motion, we did have the military service affidavit and then the Department of Defense certificate that shows the defendant is not on active duty, as well as the certificate of the defendant's last known address. Those were included in there.
Okay, thank you very much. You're excused.
Yes, thank you, Your Honor.
Granted, default judgment granted. Okay.
Thank you. May I be excused?
May.
Sorry. Thank you. Have a good day, Your Honor.
You too. Okay, let me see. Next is Stephen Isaac Gonzalez versus Lincoln Transportation, etc.
Good afternoon.
Yeah, Fred Hutterer, Mr.
Yes, sir.
Okay.
Yes, Your Honor. I am a counsel for Lincoln Transportation Service, Inc. and Jorge Antonio Lopez.
Okay. And then
Charles,
yeah.
Charles Rimmon on behalf of defendant Samantha Maria Aranda and cross-claiming against defendants Lincoln Transportation Service and Jorge Antonio Lopez.
Okay. And what about Stephen Isaac Gonzalez? Is anybody here for him, or is he here?
Your Honor, I haven't heard from him since yesterday, and I haven't heard any indication that he would not be showing up today.
Okay, good. Thank you for that information. This is a request for mediation?
That's correct, Your Honor, and if you'd like me to address the court on this matter, I can.
It's okay. Arbitration is the one that I usually go into. So if any parties already thinks that it's ripe for mediation, is there anyone, are there any lawyers here thinking that it's not ripe for that?
No, Your Honor.
No. Okay. So it's a motor vehicle accident?
That's correct, Your Honor.
And the nature of the damages, how severe?
There's, neck and back injuries as far as my client. She got cut off by a semi. Her vehicle spun out of control and then wrecked into Stephen Isaac Gonzalez, who had a claim against my client and also Mr. Hutter's client.
Okay.
The issue that we have before you to appoint a mediator is Mr. Herter and I have already agreed to use Carlos Cardenas for our mediator. However, the plaintiff's counsel wouldn't agree to any mediator. And coincidentally, it's not even the counsel for plaintiff, it's the paralegal. I've yet to have any communication with plaintiff's counsel whatsoever in this case.
Okay. Well, listen, let me just say, I don't like to get involved on the negotiations and stuff like that. And I think sometimes by just ruling, I can solve the issue. And also a lack of objection by a party, regardless of who made that decision, just is not kosher in trying to get the case moving. So I'm going to appoint Carlos Cardenas. I'm sorry, you said Ricardo? No, it's Carlos, right? Yeah, I'm going to
Yes.
appoint him as an acceptable mediator in this case. And I would like, and submit whatever order you need to compel the other side to come, and notwithstanding their opposition to it, because they're not here right now, and we're not on the record. But I'm appointing Mr. Cardenas, and is 3 months enough time as a deadline, or do you want shorter, or what?
I think that's fine, Your Honor.
I agree, Your Honor. 3 months should be plenty.
Okay, so please mediate it by the end of by, uh, by the end of August, in case anybody has summer vacation. And then Robert set it up for status, and any other motions that get filed after that date. Okay?
May I request that the hearings be in person, Your Honor?
They can be in person. Is there any reason why, is there anybody here who doesn't want them in person?
No, Your Honor. In person is fine by us.
Okay, so I'll have Robert, the next status hearing is in person, please.
Judge, and how far out, Judge?
Well, by the end of August, I guess it's second week of September or afterwards.
Yes, sir.
And the status hearing would be good to have also to set a jury trial in case there's no jury trial already set. Is that correct?
I don't believe so, Judge. I'll have to look.
Yeah. So status hearings usually result in a jury setting, and my inquiry about mediation and any other matters that need to be taken up. So I can do it that way. Let me also just tell you, I don't know who's going to succeed me. It doesn't sound like this case would be going before I retire. So act accordingly. If
Judge,
you're
it is
in a rush to
set
have
for,
me, then hurry up and get to that point. But, the
Judge,
lawyer for Tony Landavaso isn't even here. I'm
Judge,
sorry.
this is Robert, Judge.
Yes,
I want to make sure that I'm on the right case.
yes,
It's Stephen Isaac Gonzalez versus Lincoln Transportation, yes?
yes.
So it does have, Judge, a status hearing set already for September 17th,
Oh, perfect.
and it has a jury docket call on October 28th.
Okay, so you're already set for trial. You'll get your mediation by then. And then Mr. Justin Raymond Rayom, the lawyer, he's not here, huh?
Well, the alleged attorney is supposed to be involved in this case. That again, it's always been a paralegal. His name is Salazar, so I can't really speak. Maybe Mr. Hutter can talk to who he's actually talked to or dealt with.
Yes, Your Honor, I'm happy to reach out to him. We emailed yesterday, Johann Salazar, and his client is in the process of settling their claims against Lincoln Transportation and its driver. And so I'll go ahead and reach out and see if he's aware of what happened today and make sure that we get mediation set.
I don't normally sign mediation orders, but if he's not going to be here, can somebody please submit the order so that he'll have notice from me? Yes?
Yes, Your Honor.
Okay. Either Mr. Hutter or Mr. Ruman, please submit an order for mediation before a certain date, and then go from there.
Understood, Your Honor.
That way I ordered it, and I don't have to rely on this. And again, just commenting on this Zoom process, you can include on there that all future settings should be in open court in Paso County, the forum court. But that way, if it's all in writing and I've ordered it, the succeeding council can take all of that into account. But only to comment that, when you have out-of-town counsel, and they probably can benefit from the Zoom hearing, and then they don't show up to a hearing that I have. You know, some courts would have a show cause hearing. Why I shouldn't hold them in contempt? I'm not going to do that, but that's part of the problem with Zoom hearings is there's a casualness about it that parties think they don't have to show up. So, you know, let him come all the way to Austin. I mean, to El Paso from Austin, if he wants to be that way, or to just make it easier on me and the other parties. So we're not trying to work around the whim of somebody who doesn't show up for a court-ordered setting like this one. Okay?
Yes,
I'm
Your Honor.
deliberately not on the record saying that, but just so you all know. Thank you very much. You're excused. You're excused.
Judge, this is Ryan with Paseo, on the case we started with.
Yes, sir.
If I can jump in real quick.
Okay, hold on one second. Just before you do that, so the lawyers are excused if we're through with Stephen Isaac, Mr. Ruman, and Mr. Hutter. You're excused unless there's anything else we need to take up?
I have another hearing in front of you, Your
Okay,
Honor.
I'll take that. No, it's okay. If it's another one, I'll take you up later. But let me get this from Mr. Green and the parties on this other case.
Yeah.
Yes, sir.
Thank you, Your Honor. So I've spoken with both Mr. Stepik and Mr. Mann, and we are all agreeable to setting the motions for summary judgment for a future date. I think the preference is in person, but given the circumstances, they're often another place, me here, as well as some testimony that happened at a deposition just a couple weeks ago that'll change things. I think it will actually be better for the motions to be reset. And I'm wondering if we could actually get a date now, since we're all together in the same room.
You can, and I'm glad you're the spokesperson because I think you're the one most put out by what ended up happening. And again, I apologize. If anything happens, it sounds like something could even happen before the hearing on the motions for summary judgment. But when do you want them set?
I think May and June. I know I've got a lot of availability, and so I'd just be interested in hearing what dates are available.
For me, I mean, I've already had plans Memorial Day onward. So the
July.
Trying to think. Yeah. Yeah, July's fine.
Okay.
Robert, get a setting for the end of July, and if it has to get reset, you'll get a notice from my court. And then also, Robert, it'll be a setting in open court, and then of course it'll be in the afternoon, so that I don't have anything else after it. And actually, it might even give you extra time to meet in person to see if maybe you can even resolve anything else before the hearing.
Judge, July 31st is available.
What day of the week is it?
Friday.
Okay.
Also
that
July.
Works
also
for
July
Paseo.
20. Also July 24th, which is also a Friday.
Which one?
I'll do either, Your Honor. This is Mr. Mann. I prefer the 24th, but
okay. If everybody's okay with 24th, I'll do that. Because Mr. Mann is
Your Honor, I'll make either one of them work.
Yep. July 24 works.
Okay. Thank you, Mr. Green. Have a safe trip home.
Thank you so much, Judge.
All right.
And will there be a notice come out with a time?
Yes, he's going to issue the notice and send it to you, I guess, by email.
What kind of hearing is it, Judge?
It's going to be on the motions for summary judgment.
And that there's 3 of them currently, and it'll be a live hearing, right?
Live hearing, and did I hear there's going to be testimony?
No, I think he's talking about some depositions that occurred.
Oh, okay. All right.
Judge, if I may ask, how long do they anticipate the hearing to be?
If you set it at 2, that ought to give us plenty of time. Plus an automatic and probable willingness of the parties to wrap it up before 5, since it's Friday.
All right, Judge, it'll be set for July 24th at 2 o'clock.
Thank you very much.
Thank you.
Gentlemen,
Thank
Thank
you.
you, Your Honor.
Are we excused, Your Honor?
sir. Thank you.
Thank you.
Thank you.
Okay. Miss Jostrom.
Yes, Your Honor.
I'm sorry, somebody had a case, and he left. Thought he had another case. Oh, Mr. Ruman, yes, let me take him up. So, Mr. Ruman, what other case do you have?
The cause number is 2025 DCV 1633. It's a motion to compel, Your Honor.
Okay.
I think there should be a Mr. Pritchard and a Mr. Rago on this matter as well.
Okay.
I'm here, Judge.
Okay, Mr. Pritchard. Okay, let me put this one on the record. Rachel, tell me when you're ready.
I'm ready, Judge. Thank you.
Thank you. Cause number 2025 DCV 1633, Suzette Jimenez versus Brianna Saenz, Tanya Ornelas, and Myrna Workman. May I have announcements of counsel, please?
Charles Ruman on behalf of the plaintiff, Your Honor.
Wayne Pritchard. On behalf of Tanya Ornelas.
Hold on. Who are you on behalf of, Mr. Pritchard?
Tanya Ornelas.
Okay. And then is there anybody here for Brianna Saenz or Myrna Workman? Can anybody tell me who the lawyers are for these individuals?
Judge, this is Richard. And you signed an order allowing Jeff Rago to withdraw as those attorney for Myrna Workman and Brianna Saenz.
Okay, Mr. Pritchard, you have a lot of echo on your, I don't know if it's you or could be you because I haven't heard it in others. Okay, thank you. So, Mr. Pritchard, explain to me again on the status regarding the other parties and their lawyer or lawyers.
Mr. Rago was representing Myrna and Brianna, and you signed an order allowing him to withdraw.
Okay, when you say that I signed an order, was it an order that you opposed, or did you have an opportunity to oppose it?
No, Judge, we didn't have a hearing. You signed the order yesterday.
Well, I'm sorry. Hold on, let me check on that. Excuse me 1 second. Okay, I know that I'm on the record still, and my co-coordinator, of course, has been listening in. So, Mr. Vasquez, can you please explain regarding the order to withdraw?
Yes, sir, Judge. I received a phone call yesterday in reference to the motion to withdraw from Mr. Rago's office. They relayed to me that it was an agreed order.
Mr. Pritchard, I just see you shaking your head, so I take it you didn't agree?
Well, I wouldn't be honest, Judge. I don't like to oppose those kinds of motions because I don't know what the reason is for it. So I can't say I'm in agreement. I have had no conversations with Mr. Rocco over it. I don't know that I would have opposed it, but there was just never a hearing to express that.
All right, thank you.
Or a conversation to ask me if I did or did not.
Okay, Mr. Ruman?
I concur with what Mr. Pritchard has said. I just have no knowledge of him filing a motion or even an order presented to my office. And not that I would necessarily disagree with that. I just haven't been presented with anything.
All right, is there anybody else here on that case? All right, so I am making a record, and I don't want to get into this, but I got to make a full disclosure and put this on the record and probably refer this case to another judge. So I recently ran, I was going to retire and am going to retire from my district court position. And I ran for a county court at law position, and Mr. Rago was one of my opponents. And I have a good relationship with him. One of the reasons I went on the record here is precisely, though, because of those circumstances. And I had no idea about the withdrawal. I handle a lot of routine matters like that based on information given to my staff. And I do provide electronic signatures on routine matters. I would have considered that a routine matter if we went on the representation of a lawyer saying that there was a mutual agreement. Now, here we are at a hearing the next day, and you know, that's odd that this was done. It could have easily been taken up here, but everybody exercises their own professional judgment the way they do. So, I'm going to provide this record, and I'm going to recuse myself from this case and send it to somebody else to handle the situation however they choose to handle it. As a judge, I wouldn't just go on the parties whenever it might be something like this. For example, I don't even know who called from his office. I know that his daughter is his partner, works there. He also probably has staff. But as a judge, I don't think anybody in someone's office ought to make representations about other counsel unless they're true. And you all aren't under oath. I'm just, you know, maybe one of your staff agreed to that or not, but I'm leaving it there. I'm just making this record. And again, I'm going to recuse myself from the case. And I'm not going to apologize except just to tell you I regret any inconveniences. But I hope you understand why I'm doing this under these circumstances. We just are the runoff. Well, actually, yeah, the runoff for that election, which we're not in the runoff, is going to occur in May. So it was just a recent election. I don't think that it has anything to do with this, other than the fact that it does have something to do with why I'm recusing myself. All right.
Judge, just so you know, Judge, the weird coincidence, I'm running as a Republican for your court.
Oh, really? Okay. But not for this court.
Yes, the 168.
Oh, as a Republican. Oh, my gosh. I didn't even know there was a okay. Well, welcome.
Mr. Pritchard, are you recusing yourself from this case?
He doesn't need to. That's an even better reason, and it might look better for all this other stuff going on. But I'm going to order that this record be filed into the record not as a private record, that it be filed into the record of this cause, and then everything's all on the record, including Mr. Pritchard, your confession that you're running again. I sure am glad that I'm retiring, so I don't have to go up against you. I'm being facetious and comical. Okay, good. Well, good luck to you. Yeah, there's two other gentlemen that are on the runoff to be the Democratic nominees for this court. Y'all take care.
Thanks, Judge.
And then Rachel, if you'll please complete the record and file it in this cause. And then the last thing is, I'm making an oral order. And so it's good that I'm filing this record into the record to withdraw my order granting the withdrawal of counsel on this case. So I'm not going to draft it. It's all in the order there. And the record's going to be presented to Mr. Rago, and he will be getting notices of any settings on this case.
Thank you, Judge.
Right. Mr. Pritchard, if you were the judge, well, off the record, if you were the judge, would you handle it this way?
Judge.
I'm kidding. Don't even tell me.
No, I'm just, when Mr. Ruman asked me, I was thinking, man, I could be judge in the 168 when this case goes to trial.
Yeah. I actually got called for jury service on one of my cases once. You know, stuff like that happens. All right. Y'all take care, and I hope it was entertaining for anyone that's left on this Zoom. Thank you. You're excused. Okay. I just need to make sure this is taken care of. So let me just take care of this before I continue.
And we will return your call as soon as possible. Thank you.
Okay, so Miss Jostrom, or how do you pronounce your name?
Sjostrom.
Yeah, you've been in my court before.
Yes, sir.
Okay, so let me just take you up, and then I don't know if you're in that order or not, except, it's a collection matter probably, and you're usually pretty efficient, so who are you here on?
Thank you, Your Honor. Yes, I'm here on your next two cases with GECU being the plaintiff, and I represent the plaintiff,
All right,
GECU.
all right. What
And I
did
was
you
going to
think?
say to that prior hearing, I didn't really consider El Paso a small town, but it seemed to be a small town on this Zoom hearing.
I'm serious about the casualness of Zoom hearings. So I hope that, they have the same casualness in Houston or Austin or whatever. It's just been lawyers like yourself, for example, have preferred Zoom hearings so you don't have to fly out here
Yes,
or
sir.
get local count. Your client doesn't have to get local counsel. But anyways, yours are default hearings. Robert, if you can look up the two GECU cases and see if anything got filed. Yeah, it was entertaining. You're gonna miss me when I'm gone.
Yes, yes, definitely.
You're in Dallas.
Dallas.
Okay.
Everybody's pretty strict in Dallas, I would say. The judges on Zoom calls, they're no nonsense and why didn't you do this and why isn't this, very strict.
Well, I don't, because we have an audience, I don't want to say the reputation that I've heard about Dallas lawyers.
Dallas lawyers?
Let's just
Uh-oh.
say they're all familiar with the ethics code for lawyers and all this stuff. Okay, so Robert's looking that up, but these are just conventional default hearings. Let me know about the Guillermo Saldaña, et cetera. Assuming they didn't file an answer. It says here deceptive trade practices. What kind of
There are no deceptive trade practices. It's simply a debt collection.
yeah, so it's the clerk, our clerk posted it that way. I don't know how they post, but so it's a debt collection. How much?
On Guillermo. So there's a loan against Guillermo A. Saldano individually, and that amount is 13,307.78.
Okay.
And there's a second debt against both Guillermo A. Saldano and Guillermo Antonio Saldano Jr. It's jointly and several, and that is $36,593.51.
Mm-hmm.
And then
Okay.
we're also requesting foreclosure of a security interest in a Ford Mustang.
Okay.
It has not been recovered.
All right. And so your default judgment differentiates as two separate claims against the two different separate defendants?
Yes, Your Honor.
Okay. And then what kind of attorney's fees are you all asking for?
$2,500.
Okay. And then when you say about the the automobile, is it like a replevy or you want authorization to get it back or what?
Yes. We're going to put a provision in the judgment, or I did, that allows them to request a writ of possession after the judgment's taken to get it back. But as I recall, they couldn't find this vehicle, and so I think it's probably in the wind.
So are they going to assign the writ of attachment to me?
It'll be a writ of possession.
Possession? Come to my
Yes. Yes, it would be, we request an issuance of a writ of possession from the clerk. The clerk issues it, sends it on to the constable or sheriff, and the sheriff or constable attempts to locate it.
You're going to do it on the judgment. Okay.
Yes, sir.
I'm not needed after that. Okay. It's not a repo.
Right.
You're not coming to me on a repo. I got it.
Judge, this is Robert. There are no answers filed on either case.
Okay. And then tell me about Emmanuel Villarreal.
We have one loan on this one as well, Your Honor, and the amount is $21,113.63. And we're requesting post-judgment interest at 6.97% and costs of court and also attorney's fees of $2,500. And we did serve him by substitute service.
Well, let me just ask you, is it 2,500 like within your schedule? For a lawsuit like this, a default?
Yes, Your Honor,
That's fine.
we were
No,
lower and we've gone up since inflation, basically.
no, well, you all used to be pretty reasonable, but and there has been inflation. And then also, recovery is based on, on a spectrum of collectibles, I imagine.
Yes.
But it's not an unreasonable fee. I was just curious since it was exactly the same, different amounts, etc. But on both, I don't have a problem with those attorney's fees.
Okay.
Anything else?
Nothing further, Your Honor.
Okay. Well, see you at the next one.
Yeah, I will. Thank you, Your Honor.
Take care of your excuse.
Thanks.
All right. Who's next? Or who's left? Hold on. I have one more case. Nomex Corporation versus Victor Gustavo Estrada Hernandez. Oh, I'm sorry. That's not correct. That's at 2 o'clock. Who's left, please? Or why is anyone still here?
Judge, we're here on case Yvonne Guillen versus Everidge LLC. It's cause number 2023 DCV 0091.
Well, it doesn't mean it's not set, but it's not on my docket sheet. Robert, or can you help me, Robert?
I'm looking, Judge.
Okay, thanks.
Yeah, Your Honor, good morning still. This is Angelica Carvajal on behalf of the plaintiff. I can explain. We filed a motion for continuance and we requested a emergency hearing. So that's probably why.
I understand. Okay. No. Okay. I was told about it yesterday and I don't have a problem with having this emergency hearing. And I take it that all interested parties are represented by counsel and they're all present here. Is that correct?
Yes.
Okay. And then the very brief description that I had was continuance on, well, since it's your motion, Ms. Carvajal, can you please, anybody want a record or do you want me to just hear it?
I don't need a record, Judge.
Okay. Ms. Carvajal, please orient me on what this is all about.
Yes, Your Honor. So the defendants, Defendant Everidge and Defendant Caxton, they both file no evidence motions for summary judgment, I believe last month. And so today will be the deadline for the plaintiff to file a response. The reason why we file a continuance and requested this hearing is because we just don't have mainly pretty much the expert, the engineering expert that we want to designate. Once we get on the record, obviously we'll argue my motion, but if pretty much the plaintiff was required to answer to the motions for summary judgment, because there's not a discovery control plan or a trial date, the plaintiff will be forced to disclose her expert witness and their preliminary opinions on the matter.
But what does that have to do with a motion for summary judgment?
Just, so this is a products liability case. It involves a walk-in freezer. The plaintiff walked into the freezer and then the door closed. She was trapped inside for at least 20 minutes or so. And despite her efforts of trying to push the door, but she was, like I said, trapped inside and she sustained injuries. So we are going against these two defendants. One who is the manufacturer distributor of the
Okay,
walk-in.
let me interrupt you there just to, so on the no evidence, I take it they're saying it's so obvious, grant our summary judgment, and you're talking about a factual issue?
So yeah, pretty much yes. So the reason why in this case, there's like the plaintiff will anticipate to designate an engineering expert, so we can obviously prove why and explain to the jury why this walk-in freezer was dangerous and effective. So we need those.
That's Carvajal. So what I'm trying to focus on is the summary judgment procedure. Okay, so I take it I have discretion to grant continuance on good grounds, and then you tell me that theirs is a no evidence summary judgment, and I take it it's not based on I mean, of course everything's a legal procedure, but the argument is does incorporate the facts into it on their motion for summary judgment. Would that be correct, Mr. White?
I believe, yes, we've both filed no evidence motions for summary judgment, and Ms. Carvajal's asking for more time to develop some of the facts, if that answers the court's question.
So thank you very much. So for me, rather than for you to respond to that, and then new facts pop up for reconsideration or whatever, I would prefer to give you the continuance and hear from the other lawyers what would be a reasonable amount of time for me to continue in their, for their motions for a case like this. So what did you have in mind? You get a continuance and what? Until when?
Well, Your Honor, I was gonna leave it up to the court, but I think a good starting point, if the court wants to a little bit of guidance, we want to get a discovery control plan as soon as possible. If we get a trial date today, I will diligently work with both opposing counsels, and once we have the deadlines for those expert designations, again, we'll go from there unless the opposing counsel disagrees.
Okay, but yes, it's great that you all can work that out, but they can stand on their motions and expect something from me, and then if I'm reading them, and then you even want time for a response to their motions, I would have to grant it if I see it as meritorious without you having the benefit of a response. And if you're telling me that you need some more factual information so that you could have the benefit of a response, that's one thing. But the other that you're talking to me about just presumes that, you all are going to agree as lawyers to do this. And I see Mr. White here, and from his answers and all, he can, and I'm sorry, sir, what is your name?
Randy Thairless, Judge.
Yes, sir. They can stand on the procedure and insist that I do that. So in this particular case, what I would prefer to do is grant your continuance, but put a closing date so I can cover these motions, or I won't cover them after you talk to the other sides, or let's just say that some facts are developed that you're able to put in there that they would understand as lawyers. Okay, well, she might have us on that, or they file a response. They can carry their motions. They can carry the procedure for summary judgment. And what you're asking me to do is, without asking them how they feel about it, you're saying, let us do this because it'll be more efficient. But what I'm saying is, I'm not going to get involved with efficiency and negotiations for that. I see that they go to your negotiations on a settlement or a resolution or that kind of thing that I don't want to get involved in unless you're asking me to do that, either side. So, well, let me first ask, Mr. White, do you understand what I'm saying?
I do, and
Okay. Right. So without me doing that, I can give you a continuance because it's an emergency and because there's a high price to pay. If you don't file according to the procedure, then you have to rely on another discretion that I might have to excuse you. So I do recognize and respect the fact that you did it the right way by coming to me for an emergency hearing. And then if in between that, you all are negotiating to move the case on and all, it wouldn't surprise me that we won't have these or that you'll file your motion and I can go on them. So I'm going to give you, I'll give you, because you're not telling me, because of what you're asking for is outside the realm of any certainty for me. I'll give you a month to file your response, and you have a month to talk to the other parties or to even reset this for, for a hearing to continue your request for a continuance. And I'm doing a lot of that without hearing from the other sides on, them trying to explain I don't need that or not. I'm just doing that as to grant your emergency request, and then you all work it out like you normally do, or have your motions. Now, is everybody in El Paso?
No,
I am,
sir.
Everybody is?
No, Judge, I'm from Sugar Land.
Okay. And who are you representing?
I represent Quezon Industries, Judge.
Okay. Until further notice, I don't mind. I don't mind having another Zoom hearing, but eventually you may have to get local counsel or whatever if this becomes more complicated. So I don't mind having the next Zoom hearing on this. I'm giving you a month, and I am not giving you a setting. It's on you and anyone that wants to file a motion to memorialize my ruling on a month of your continuance. It's on you to get the next setting that you need in the regular course, or if you're going to continue on these motions, then Ms. Carvajal, I would say it's on you to ask for another continuance or be prepared for the hearing by Zoom, or if any party requests that it be done live, I'll do it that way.
Understood, Your Honor.
Okay. Mr. White, are you okay with that?
absolutely, yes.
Okay. And Mr. Fairless, you're okay with that?
Yes, sir, I am. And Judge, I'm happy to come to El Paso for a hearing in person. It does not bother me.
We have a lot of lawyers who like to come to El Paso and have an excuse to come. So I'll bear that in mind. Okay?
Okay. Yes, sir.
And then Ms. Lu, you are here for whom?
Yes, Your Honor. I represent Jesus Ignacio Zapata, doing business as JC Services. It's a co-defendant in this case. However, we have settled with the plaintiff, but I'm still here because we haven't finalized our paperwork, and I'm still actually a defendant in this case until I'm non-suited. So I'm just here because I have no opinion or or anything on this hearing, but I'm just here because I'm still in the matter.
Okay, and you're a lawyer.
Yes, Your Honor.
You're not okay. So are you okay with what I just said?
Oh, yes, Your Honor.
Okay. So y'all are excused. Have a good, well, I can't say weekend yet because it's not Friday. And
We're pretty close.
We'll see you at the next one. Okay.
Thank you. Y'all have a great day.
Thank you.
Thank you, Judge.
Thank you.
Yes, sir.
I believe that's the docket, Judge.
All right. Thank you. And then I got a 2:00 plea, right?
We have a 2 o'clock plea and a summary judgment, I believe.
The summary judgment is going to be live also.
That's correct, Judge.
All right. Thank you.